Gracias, Eduardo. No, solamente pues en calidad de funcionario público del departamento, quería darle la bienvenida a este evento que realmente es muy importante, es un evento de orgullo y que ha estado organizado por el profesor Luis Eduardo Gama. Él va a presentar a sus invitados. Profesora, muy buenos días. Y nada, creo que simplemente pues para el departamento es muy importante que se planteen estas aproximaciones filosóficas a problemas que algunas personas piensan que no nos atañen, que quizás son problemas que tienen que ver con los politólogos o los sociólogos, inclusive los psicólogos. Así que para nosotros es importante dejar esa impronta de que un problema como el de la justicia transicional es un problema que amerita urgentemente una mirada filosófica o miradas filosóficas. La justicia transicional pues tiene un significado muy especial en nuestra historia, no solo porque la idea de transición marca como puntos en la historia, todos sabemos de que estamos hablando de del acuerdo firmado con las FARC y el intento de haber iniciado con ello una etapa de pacificación del país, que por supuesto ante semejantes acontecimientos históricos del conflicto ameritaba una reconceptualización de lo justo y de la justicia. Y todos sabemos acá que ahí ha habido una dificultad cultural inclusive en términos de entender un modelo de justicia que no sea restaurativo y que más bien esté orientado sobre el concepto no restaurativo y bueno, ya me confundí con los dos, pero ustedes saben de lo que estoy hablando. Y para mí es muy importante, yo no venía a hacer ningún discurso, pero para mí es muy importante esto porque ese modelo de justicia incorporó un concepto muy importante que es la idea de que la verdad genera justicia, o sea que la justicia está apoyada en la verdad, en la posibilidad de que las personas, los ciudadanos, víctimas, victimarios, todos los miembros de la sociedad accedan al conocimiento de los hechos que calificamos como verdaderos al respecto del conflicto. Entonces es una idea de justicia que tiene elementos filosóficos pues muy relevantes, que claro, todo el mundo se pregunta, bueno, ¿cómo es la verdad? ¿Cómo se establece la verdad? Entonces hay la aproximación filosófica al tema de la justicia transicional me parece de lo más relevante. Saludo el simposio que ha organizado el profesor Gama y espero que de allí, y seguro, saldrán reflexiones que ojalá podamos tener luego materializadas en textos que podamos todos consultar y ver para ver las reflexiones que se han dado. Muchas gracias, profesor Gama, profesora, muchas gracias. Extienda por favor mi saludo a todos los participantes en el simposio y los dejo con la programación ya del evento. Muchas gracias.
Bueno, William, gracias. Sí, mientras esperamos de pronto que lleguen más invitados y participantes interesados, que la lluvia retrasa, pues yo quería contarles un poco cómo surge la idea y por qué pues digamos, porque este es el resultado final de un proyecto que hacemos con el grupo de hermenéutica desde hace ya como año y medio, no sé, tal vez un poco más, 2 años. Eso comienza siempre pues pensando más en la justicia, en mi caso personal fue siempre ligado a cosas que trabajo con la filosofía del idealismo alemán, Hegel, Kant, con la idea de justicia y en el entretanto pues se dio la reflexión sobre la justicia transicional y como la constatación de que en los debates sobre justicia transicional y sobre todo pues digamos en esa extensísima literatura que encuentra uno sobre justicia transicional, hay muy poco tratamiento filosófico. O sea, realmente esto siempre se hace más desde el lado de los estudios jurídicos, sociológicos, historiadores, trabajan mucho eso, politólogos por supuesto, pero cuando se mira como el fundamento filosófico del asunto, pues realmente los debates son relativamente rápidos, 3, 4 nombres que siempre se mencionan allí: la justicia transicional rompe con el paradigma retributivo, etcétera, pero digamos que la impresión es que faltaba más acercamiento desde la filosofía a esa problemática, y entonces ese fue como el objetivo del grupo, comenzar a trabajar en eso, y pues bueno, el resultado era final, la idea era como mostrar un poco lo que habíamos hecho entre tanto en este simposio que organizamos para este semestre. Son 3 días, yo creo que ustedes tienen la programación, son 3 días pues como de intenso trabajo, espero, donde pues hay un poco de todo, es decir, tenemos pues estudiantes y profesores que hacen parte del grupo de investigación y que estuvieron en todo el trabajo durante todos estos años, 2 años, perdón. Luego también vienen invitados pues la profesora Glanert y magistrados que trabajan cercanos a la JEP, ¿no? Y pues que ustedes conocen aquí, como el profesor Rodolfo Arango, Rodrigo Uprimi, un gran jurista. En fin, son 3 días que vamos a trabajar mañana y tarde. La idea de hacer esto, de que sea un simposio, es que pues no se trata de algo masivo como para un gran público, sino también pues como una cuestión más entre especialistas. Por eso la idea es que el grupito fuera pequeño y que por supuesto haya intervenciones del público si hay preguntas, pero pues que se concentrara en un trabajo entre los que pues estamos como de panelistas principales. Ya en términos logísticos, creo que ustedes todos tienen la programación. Hoy vamos a estar aquí en la Universidad Nacional. En la mañana vamos a estar aquí en el auditorio Margarita González, y después del almuerzo a las 2 de la tarde pasamos al Salón Oval que está aquí al lado. Mañana somos recibidos por la Universidad de los Andes. Si ustedes quieren asistir a la Universidad de los Andes, tienen que inscribirse por un código QR que está bueno, ahí está, pero yo no sé si de ahí uno lo puede sacar, ¿sí? O bueno, yo los puedo pasar circuló pues el flyer que tenía el QR, porque el primero salió aún sin el QR, no sé, ahí no está, sí. Este no tiene el QR, pero hay el flyer que circuló, y entonces si alguien lo necesita pues se puede hacer, porque eso requiere una inscripción previa. Esto pues en cuanto al esquema del evento, y pues yo sí quiero presentar ahora a nuestra invitada internacional, la profesora Simone Glanert. Cuando yo me puse a revisar pues como alguien que trabajara, porque es una combinación como especial, ¿no? Es decir, que se ocupe de temas de filosofía del derecho y filosofía de la justicia desde una perspectiva hermenéutica también, porque pues el grupo es de hermenéutica, y que además pues tenga conocimientos en derecho, pues esa combinación particular la cumplía la profesora Glanert. Entonces pues la invité, aceptó nuestra invitación, estamos muy contentos que esté aquí, y entonces pues vamos a comenzar, porque ella va a leer su conferencia en inglés. Vamos a pasar aquí unas diapositivas para ayudar a la comprensión. Después ustedes pueden hacer las preguntas en español o en inglés. Para eso pues Samuel aquí, nuestro asesor traductor, él se encargó además de la traducción de los artículos. Muchas gracias, Samuel, además, y pues nos ayuda con la traducción si es necesario, así que no duden pues en formular sus preguntas en español si ese es el caso. Bueno, quiero presentar entonces a la profesora Simone Glanert, que ella es graduada de la Sorbona y ex becaria Rudolf Schlesinger en la Facultad de Derecho de Cornell. La doctora Glanert es profesora e investigadora en la Facultad de Derecho de la Universidad de Kent, en el Reino Unido, y se especializa en Derecho Comparado, Interpretación Jurídica, incluido la traducción, y el Derecho Animal. La doctora Glanert se ha desempeñado en varias ocasiones como profesora visitante en Canadá, Francia, Qatar, Rumania y Suiza. Su monografía, titulada de la traductibilité du droit, evalúa críticamente las posibilidades y límites de la traducción jurídica desde una perspectiva interdisciplinaria. Se ha encargado de la edición de diferentes títulos, entre ellos Comparative Law Engaged in Translation y Law's Hermeneutics Other Investigation. También la doctora Glanert ha actuado como editora invitada para números especiales de la revista Law and Translation, Comparative Legal Reasoning y Comparative Animal Law. Y es coautora de Rethinking Comparative Law con Alexandra Merchescu y Gottfried Samuel. Actualmente la doctora Glanert se encuentra escribiendo un libro sobre la ley comparativa animal, que aparecerá en 2029 en Cambridge University Press, y que aboga en este libro a favor de una sinergia entre los campos del derecho comparado y el derecho animal. Bueno, pues creo que es todo. Yo le agradezco otra vez a la profesora Glanert, los dejo con usted, con ella.
Thank you. Does this microphone work? Yeah, I think so. Good morning, everyone. Buenos días a todos. I have entitled my presentation Gadamer's Recht, a resource for transitional justice. I am based in the heart of England. And in the heart of England, transitional justice is something that happens elsewhere. The most proximate distance being Northern Ireland, which is in fact located light years away. For my part, I work as a comparatist, that is, as someone who is interested in foreign law. And for a comparatist, it is precisely what is taking place elsewhere that proves of abiding interest. I'm therefore very grateful indeed to Professor Gadamer for having invited my presentation in this exciting intellectual event on transitional justice here in Bogota, elsewhere. Transitional justice is one of those multifaceted configurations por excelencia, requiring transdisciplinary perspectives. And the standpoint that I would like to adopt is the one of interpretation, which I locate as I frame the matter at the intersection between law and philosophy. Interpretation is key to transitional justice for many reasons. For example, interpretation shapes how a society defines, remembers, addresses past mass atrocities. It is also interpretation that determines how victims' experiences are understood and which narratives of violence are officialized. It is therefore interpretation that decides which stories will define the new post-conflict or post-authoritarian order. It is also interpretation that informs how legal mechanisms, so for example, trials or truth commissions, understand international law. For example, legal concepts such as crimes against humanity or victims. These concepts require interpretation. They are not self-explanatory. And they require interpretation to fit specific national situations, thus ensuring that international justice is made relevant to local experience. Of course, in most practical terms, interpretation is used in courts, in commissions, to assess evidence given complex, often contradictory testimonies from victims, witnesses, and perpetrators. And ultimately, interpretation is deployed to balance the goals of retributive justice, the idea of punishing perpetrators, with those of restorative justice, healing victims and communities. Arguably, we can achieve a more sophisticated understanding of these complex challenges, interpretive challenges, arising in the context of transnational justice through the recourse to interpretation theory. Now, within the crowd of interpretive theory, I think Gadamer, Hans-Georg Gadamer, German philosopher Hans-Georg Gadamer's philosophical hermeneutics has undoubtedly become the most influential model of interpretation. Indeed, there is compelling evidence, empirical evidence, to support this proposition, not least in terms of the sheer amount of books and articles that continue to be devoted to Hans-Georg Gadamer's work. Now, I, as a comparatist, again, that is someone who takes an interest in foreign law, I have developed a keen interest in Hans-Georg Gadamer's philosophical hermeneutics. Why? Because the matter of interpretation lies at the heart of comparative law. Within comparative law, the threshold question is, what does foreign law mean? How to understand foreign law? To what extent can we understand foreign law? And these are the reasons why I have long been drawn to Gadamer's theory of interpretation. As it happens, Gadamer's book Wahrheit und Methode, Truth and Method, includes a substantial section on law. And it is my current thoughts on Gadamer's law, or as I argue, on Gadamer's Recht. I use the German expression explicitly, actually, as you will see, that I would like to share with you today. So we can move on. In terms of Gadamer's work, the interaction between law and hermeneutics resolves itself according to two dynamics. So we can see in Truth and Method actually two dynamics when we have a look at the interaction between law and philosophical hermeneutics. On the one hand, one can say that philosophical hermeneutics assists law. Philosophical hermeneutics allows lawyers to develop a better understanding, an improved understanding of the modalities under which legal interpretation takes place. And that's the view expressed by a number of academics, in particular legal scholars. And then on the other hand, there is the idea that law supports philosophical hermeneutics. That is, law would bolster the strength of philosophical hermeneutics claim. And this point of view, according to which law supports philosophical hermeneutics, this view is initially attributable to Hans-Georg Gadamer himself. My presentation will focus on this second point only, the argument according to which law supports philosophical hermeneutics. That is a matter that is relatively unexplored. As I read Gadamer, and even as I bring to bear a benevolent disposition to my reading, I must conclude that Gadamer's treatment of law, the way in which Gadamer writes about the law, what he says about the law, in my view, his treatment of law is deficient. It is deficient in many respects. Ultimately, I must in fact disagree with Gadamer. Law, at least law in the way he frames it, law in the way he understands it, does not support his philosophical hermeneutics. So that is my argument. So I will focus on the second point, according to which law supports philosophical hermeneutics. That is initially Gadamer's argument. It is an argument that remains largely unexplored in the literature, and I would like to have a look at the relevant section on legal hermeneutics in Truth and Method, have a critical eye on it, with the hat of the comparatist on, and ultimately I will demonstrate that his understanding of law is actually quite problematic. We can now move on to the next slide, please. Gadamer wants legal hermeneutics, the interpretation of legal texts, to play a decisive role within his general philosophical framework. In a salient part of Truth and Method, addressing the elements of a theory of hermeneutic experience, Gadamer devotes an entire section to legal hermeneutics. And in this section, Gadamer refers to the exemplary significance of legal hermeneutics, which he entitles Die exemplarische Bedeutung der juristischen Hermeneutik. Can I move on to the next slide, please? Why is legal hermeneutics exemplary, according to Gadamer? Well, for Gadamer, legal hermeneutics is exemplary because it shows that the concept of interpretation cannot be understood apart from that of application. In fact, the two ideas, the two concepts cannot be dissociated. Application is neither occasionally nor subsequent vis-à-vis interpretation. Rather, application is an inherent part of interpretation. Every interpretation, according to Gadamer, features necessarily an application. Inevitably, through application, every interpretation is instantaneously concretized. Interpretation, in fact, is immediately assigned to the particular task. And what is key for Gadamer is that legal hermeneutics is capable of restoring the hermeneutic problem to its full breadth and contribute to a better understanding of the proper workings of hermeneutics, not only in philosophy, but in all other disciplines, such as theology, history, or law. For instance, Gadamer's thesis is that when a judge interprets a statute that has been enacted many years earlier, the judge is always simultaneously applying the statute to a present set of facts. Another example is the historian. When the historian interprets the past, she is always conducting, at the same time, an application to the present concerns and interests. Again, for Gadamer, these two processes, interpretation and application, they go hand in hand. They cannot be dissociated. And that's legal hermeneutics' contribution. Legal hermeneutics shows that what is inherent in interpretation is an application. Now, although I'm attracted to Gadamer's understanding of interpretation, and specifically his theory of interpretation as application, my immediate concern is not so much to assess the merits of this claim. Rather, I focus on the exemplarity of legal hermeneutics that Gadamer so forcefully alleges. So remember, Gadamer talks about the exemplarity of legal hermeneutics in the context of his work. I can now move on to the next slide. Reading Gadamer closely, again with the hat of the comparatist on, I argue that his considerations regarding legal hermeneutics refer exclusively to German law and to German legal culture. In other words, when Gadamer advocates for the exemplarity of legal hermeneutics, he is basing himself on Germany only. And I hold that Gadamer's understanding of legal hermeneutics, being irredeemably German, is in fact not transposable to other legal cultures. For example, in legal cultures within the common law tradition, the United Kingdom, United States, Ireland, Australia, New Zealand, etc. In fact, in these cultures, within the common law tradition, the prevailing conceptions of law or legal interpretation diverge significantly from the German appreciation. And in fact, Gadamer's truth and method is lacking comparative sensibility. The book seems seemingly and quite naively to assume that the German legal model is to act as the referential legal model all over the planet. However, the law and the legal culture that Gadamer considers in his book are emphatically singular. They are singular German law and the singular German legal culture. And so whatever conclusions one can draw from such an examination of legal hermeneutics as undertaken by Gadamer are therefore limited to the German configuration itself. Therefore, it simply cannot be that legal hermeneutics, the way in which Gadamer configures it, would be exemplary. The singular German legal model cannot be exemplary. I would like to explain this in more detail. What is interesting to note is that when you have a look at the history of truth and method, you will see that Gadamer started writing Truth and Method in the early 1950s. And early drafts did not comprise any section on legal hermeneutics. It's actually very late, in 1959, that Gadamer added the section on legal hermeneutics in the very final version of his book. So in 1959, he inserted a section on legal hermeneutics in his book, which appeared the year later in 1960. So literally, at the very last minute, he decided to include a section on legal hermeneutics. And this timeline suggests that Gadamer ultimately came to deem law important enough to warrant significant deliberation. Right from the outset, it's necessary to appreciate that Gadamer was not at all well versed in law. As we know, his expertise lay in philosophy and in Greek philology. We know all very well that Martin Heidegger served as his teacher and primary philosophical influence in the development of philosophical hermeneutics. And now, as far as specialists on Heidegger's thought have been able to ascertain, Heidegger held no interest in law and did not write about the law. Within this philosophical circle, law did not feature. Indeed, Gadamer did not hold any law degree. And to his credit, he appears to have been aware of this difficulty. And in fact, in 1977, in a letter that he addressed to Franz Viaker, a distinguished German legal historian, Gadamer wrote the following: "It's a pity that I lack legal training so that I'm unable to formulate my intention adequately." So the question for us is the following: why Gadamer's late surge of interest in the legal? Why did he become interested in legal hermeneutics? Why did he include that section on legal hermeneutics in his book? We can now move on. It turns out that the main factor in Gadamer's belated decision to include an exploration of legal hermeneutics in his Truth and Method appears to have had to do with the work of the Italian legal historian and neo-Kantian philosopher Emilio Betti. Betti, at the time, was a considerable jurist. He was also a member of the commission that drafted the 1942 Italian Civil Code. And in 1955, Betti, at the time a professor at the University of Rome, La Sapienza, had presented his theory of interpretation, his hermeneutic theory of interpretation, in a massive book entitled Teoria Generale della Interpretazione, General Theory of Interpretation. Around the same time, Betti had also exposed his main ideas in German in a lengthy book chapter. And it's clearly this book chapter written in German that nurtured Gadamer's interest in legal hermeneutics. And in fact, Gadamer profoundly disagreed with Betti's appreciation of legal hermeneutics, which in a nutshell resolved around the ideas of method, objectivity, intentionalism. In Gadamer's own critical words, and I quote from Gadamer, "As far as Betti is concerned, he is basically too unphilosophical for me. He wants rules, whereas I want to think about the conditions under which these rules apply." So that explains why Gadamer included a section on legal hermeneutics in his book. And let me now address in more detail Gadamer's own examination of legal hermeneutics. In his section on legal hermeneutics, Gadamer draws on the writings of just a handful of authors. So he didn't do an awful amount of research, but rather he gathered some sources here and there. And apart from some references to Betti, he indicates 4 doctrinal sources only, all of them German jurists, all of them fully fledged products of German legal culture. Franz Viaker, with whom he maintained regular contact for decades, Ernst Forsthoff, a professor of constitutional and administrative law, Karl Engisch, a professor of criminal law and legal philosophy, and Friedrich Karl von Savigny, a leading 19th century German professor of legal history, whose 1840 System des römischen Rechts, System of Roman Law, he briefly mentions. Now, it is perhaps of more than anecdotal interest that 3 out of the 5 German sources that Gadamer harnessed had in fact a contentious past. Betti has been described, and I quote, as a hardcore member of the fascist movement. And both Franz Viaker, who qualified as a law professor in 1933, and Ernst Forsthoff, who is in fact the author of Der totale Staat, the total state, released in 1933, these two were also very close to the Nazi regime. I don't want to explore this any longer, but it's interesting and important, I think, to note. We can now move on. In his section on legal hermeneutics, which again is about the fact that every interpretation involves an application, Gadamer mobilizes a range of specific German legal concepts. For instance, he refers to the System der rechtlichen Dogmatik, dogmatischer Zweck der juristischen Hermeneutik, dogmatische Sonderaufgabe der juristischen Hermeneutik. He mentions the Rechtsstaat, Rechtssicherheit, Rechtsordnung, Subsumptionsakt. These concepts, these very specific German legal concepts, they are so singular as to prove hardly translatable into English. And even if a translation were forced, US or English lawyers, for example, would be mystified by German conceptual terminology. Arguably more problematically, some US or English lawyers might think that they actually understand the German legal concepts, like say legal certainty or legal order, and common law lawyers may assume an equivalence across languages. But comparative law, which again is my discipline, in fact, an important part of comparative law warns against such erroneous and therefore misleading conclusions. Just an illustration, the example of legal certainty, Rechtssicherheit. It's actually an excellent example on the way in which the German understanding of the legal is profoundly at variance with that obtaining in common law jurisdictions like the United States or England. In Truth and Method, Gadamer writes how, and I quote, "In a state governed by law, there is legal certainty." And Gadamer continues by insisting that, and I quote, "Given a state governed by law, it is in principle possible to know what the exact situation is. Every lawyer and every counsel," Gadamer writes, "is able in principle to give correct advice. In other words, he can accurately predict the judge's decision on the basis of the existing laws." So that's Gadamer's thinking. According to Gadamer, and I quote, "It is always possible to grasp the existing legal order as such." At this point, I would like to refer to the late Stephen Wadhams, who passed away in 2023 at the age of 80. Stephen Wadhams was a leading common law lawyer of genuinely international standing. He was a distinguished professor at the University of Toronto's Faculty of Law for more than 50 years, the author of 9 books on the common law, including leading textbooks and casebooks on contract law, remedies, and damages. He addressed the issue of legal certainty in his scholarship. And Wadhams observed, and I quote from Wadhams, "The question of what the law really is on any one point can never be asked by a practitioner, however learned, in a form that can yield a conclusive answer." I don't know if you've read about the recent US Supreme Court reversal on abortion from June 2022. That is just one spectacular example of the inherent indeterminacy of law that Wadhams emphasizes. And as one reads Wadhams, it seems hard to imagine a starker contrast with the German position as Gadamer expresses it. But of course, within the common law tradition, Wadhams was actually not alone in holding as he did. Consider Tony Weir. Tony Weir, the eminent Cambridge common law lawyer and comparativist who died in 2011, he referred to the common law, and I quote, as a tradition of working disorder. Indeed, the common law tradition displays, and I quote, an instinctive acceptance of genuine indeterminacy, which can most notably be seen through the lack of a civil codification. There is no civil code in the United States or in England. And in his own area of expertise, which was tort law, on which Weir had written a leading textbook, Weir, who had a sense of humor, used to say that tort law, his subject matter, was in fact so incoherent that the only thing holding it together was the book's covers. Another striking example of Gadamer's German-oriented treatment of the law is his use of the German expression Rechtsstaat. The English literal translation, state governed by law, does not even begin to account for the semantics of the German term. Quite properly, Rechtsstaat was actually being regarded as untranslatable. And the idea that rule of law, which is often used in order to translate Rechtsstaat, might assist, it's actually highly problematic because rule of law makes no reference to state, a concept that is in effect largely absent from constitutional thought within the common law tradition. I teach public law at the University of Kent, and we don't really address the concept of state in our course. Even the expression état de droit, the French expression état de droit, which is much closer to the German term, must be very carefully differentiated because the idea has close connections with the philosophical thought of Kant and Hegel. Indeed, there is not even an equivalent in the English language for a basic German legal concept such as Recht that Gadamer harnesses repeatedly in the course of his discussion of legal hermeneutics. Why? Why is Recht, in fact, hardly translatable? Because not only does the German word mean right, so for example, Peter hat Recht, Peter is right, so it means right, but also it signifies law. So in a certain sense, for example, constitutional law, which is Verfassungsrecht. However, the German language additionally features the word Gesetz, which also means law, and in a different sense, so that the Grundgesetz, for instance, is the basic law, in effect, the constitution. So needless to add, the distinction between Recht and Gesetz is completely lost in the English translation, which can only offer the word law to translate both German legal ideas of Recht and Gesetz. My claim that Gadamer's focus is insistently on German law and German legal culture also finds significant support on account of his conceptualization of the judge, in German Richter. In fact, the judge is the main character in the pages that Gadamer devotes to legal hermeneutics. He constantly talks about the Richter, the judge. Historically, German law students have been trained to be judges. Indeed, in Germany, one is in a position to work as a judge by virtue of one's own qualifications as a lawyer. And the judgeship is a prestigious post within German society. Be that as it may, the German judge emphatically remains an interpreter of the law texts in force, whether in the form of the constitution, the codes, the statutes, or lesser legislative or ministerial enactments. To be sure, common law judges are also interpreters of law texts, albeit of different law texts, since codes have not found favor within the common law tradition. There are no codes in the United States. There's no civil code in the United States or in the UK, or in England. But there remains an outstanding difference between civil law and common law judges. In the common law tradition, judges operate as outright lawmakers over entire areas of the law where legislation, so to speak, chooses not to intervene. Example, US law, where judges decide on their own whether a contract has come into existence, where judges use the contempt of court power as strictly judicial development to enforce unpaid child support or alimony, or where judges have taken the initiative to generalize unjust enrichment as a wide-ranging cause of action, and where judges have proprio motu fashioned strict or no-fault liability for defective products. In other words, in the common law tradition, traditionally, judges enjoy lawmaking power, which is not the case in Germany. And that judicial lawmaking power can be traced to the 12th century England. And judge-made law has stood ever since as an acknowledged source of law, which is not to say that it cannot prove controversial, most significantly perhaps as a matter of US constitutional law. I mentioned the US Supreme Court decision on abortion, very controversial decision. So the power that judges enjoy in the common law tradition proves sometimes controversial. Contrariwise, in Germany, the compound Richterrecht, the law of the judge, is actually seen as best avoided. A different formulation, judicial further development of the law, in German richterliche Rechtsfortbildung, is deemed much preferable. The idea being, in fact, to minimize as far as possible the extent of the judge's interventionism in German legal culture. So when Gadamer writes that legal texts are interpreted legally in court and that the judge purports to understand the meaning of the law, indeed, he talks about the correct meaning of the law, that the judge is always concerned with the law itself, as he writes, that he is involved with the interpretation of the law. In fact, what Gadamer is doing is very much defending the classical understanding of the German judge's subservient role, which stands at considerable variance from the judge's legitimate ability within the common law tradition to make the law. The German judge is meant always to be an interpreter. And historically, the common law judge has assumed the role of a lawmaker. So it's a completely different role that the German judge occupies and that the common law judge occupies. Now, in typical German legal fashion, truth and method include sentences regarding the need for subordination to the text's claim and the requirement to interpret the law's will. And such claims, which for Gadamer do not raise any difficulty, could expect to be heavily disputed in the common law tradition. They do not speak to lawyers in the common law tradition. We can now move on. Another very interesting point is that when one has a closer look at the section on legal hermeneutics in Truth and Method, one will see that on several occasions, Gadamer draws an express analogy, a comparison between the judge and the clergyman. And Gadamer discusses theological hermeneutics at length over several pages in the very course of his section on legal hermeneutics. He identifies what he calls legal and theological hermeneutics as hermeneutics' true model. Perhaps the most striking sentence of Gadamer's, as he brings together these two discourses, legal hermeneutics and theological hermeneutics, so the most striking sentence bringing together these two discourses reads as follows, and I quote from Gadamer: "To interpret the law's will or the promises of God is clearly not a form of domination but of service. They are interpretations which include application in the service of what is considered valid. So to interpret the law's will or the promises of God is clearly not a form of domination, but of service. They are interpretations which include application in the service of what is considered valid. So one can actually very clearly see, we can move on to the next slide, please, the influence, the indirect influence, obviously, of Roman legal thought on Gadamer's work. In countries such as Germany, whose law boasts Roman ancestry, countries known to Anglophone as civil law countries, countries pertaining to the civil law tradition, whose laws hark back to the law of the city, the law of Rome, there has been for many countries an overlap between the legal and the religious, a process going as far back as the early 6th century. Roman Emperor Justinian, who is reproduced here on the slide, come back, reproduced here on the right-hand slide, the picture of Roman, we can move on one. Yes, no. Yes, exactly, thank you. Roman Emperor Justinian, who commissioned the comprehensive compilation of all Roman law known as the Digest, which became the cornerstone of the civil law tradition, styled himself at once a political and religious leader. Justinian expressly invested the Digest with a sacred character and prohibited all commentary on the text, thus ensuring that its sacred character would be safeguarded. From a historical standpoint, a German law professor is therefore effectively and meaningfully acting as a priest of the law. His referential attitude vis-à-vis the state's law text, very much an academic liturgy. In fact, note that the word priest is in fact the term Emperor Justinian himself used in the Digest to refer to law professors. Emperor Justinian already refers to law professors as being the priests. Now, as I observe Gadamer closely connecting law and theology, indeed discussing theology within the law, I do not wish to suggest that he's doing so on the basis of extensive familiarity with Roman law or indeed with German legal history, which is in all likelihood not the case. However, this analogy between law on the one hand and theology on the other hand is in fact a motion that tightly fits the German model and that could not operate, say, as regards the common law tradition, where there is no significant Roman ancestry and where law has not historically been invested with a sacramental dimension. It's actually quite to the contrary. In fact, English Reformation actively proceeded to ensure the secularization of Roman law. We can now move on, please. Thank you. In sum, Gadamer's section on legal hermeneutics in Truth and Method is thoroughly under the sway of German law and German legal culture, unsurprisingly so, since all the evidence suggests that Gadamer's limited acquaintance with law was confined exclusively, as I have mentioned, to a handful of German sources. In this sense, Gadamer can be accused of what comparators style juricentrism. That is a reductive, perspectual bias pursuant to which an observer refers the range of legal experience to his own local law. In fact, I'm minded to quote Gadamer himself in support of my claim. And I quote from Gadamer, "The interpreter finds his point of view already given and does not choose it arbitrarily." So a German philosopher without legal training, Gadamer found his legal point of view already given. He did not choose it arbitrarily, whether in terms of the concepts that he mobilized, the formulation that he employs, the institutions that he channels. Gadamer's law is therefore an all-German affair that can be connected to his personal and professional circumstances. And this all German legal arrangement is in fact deeply local and at any rate completely unextensible or untransposable to other places, such as common law countries. And it follows that Gadamer's case for the exemplarity of legal hermeneutics, remember that was the starting point of my analysis, the exemplarity of legal hermeneutics, with reference to his general philosophical project, is not established. Ultimately, Truth and Method does not feature Gadamer on law, but Gadamer on Recht. Next slide, please. I would like to make a final but important observation. Even Gadamer's picture of German law seems unrealistic at one basic level. Indeed, Gadamer's German law is strikingly benevolent, conciliatory, dialogical. Amongst many other analogous passages, the three statements that follow well emphasize Gadamer's strange disposition. So I quote from Gadamer's work: "One must look for the word that can reach another person, and it is possible for one to find it. One can even learn the language of the other person. One can cross over into the language of the other in order to reach the other. All this is possible for language as language." Another quote from Truth and Method: "When the interpreter overcomes what is alienating in the text, the tension between the horizon of the text and the horizon of the reader is dissolved. I have called this a fusion of horizons. The separated horizons, like the different standpoints, merge with each other." One final quote from Gadamer: "Language has its true being only in dialogue, in coming to an understanding." Gadamer's philosophical theory is largely influenced by Platonic discourses, dialogues. And Gadamer's philosophical theory, which again largely influenced by Platonic dialogues, does not take into account the fact that the law is largely adversarial. Indeed, law involves competing interests, charges of unwarranted behavior, accusations, lawsuits. Divorces are filed, criminal charges are brought, and constitutional complaints are lodged. Opponents are often embroiled in bitter legal disputes for many years. Meanwhile, lawyers proceed to interpret law texts in a way as favorable to their client as it is all possible, and in a manner as disfavorable to the other side as words will allow. Structurally, law, and German law too, stages conflicts of interpretation. Yet, in Truth and Method, this antagonistic dimension, the power dynamics, the politics, the fights informing the law at a very basic level, is strangely ignored. Now, how could intrinsically adversarial law operate exemplary to sustain a philosophical model that openly seeks to eradicate strife in the pursuit of harmony? Consider the trio of excerpts I have just enumerated. Remember the three passages that I've just read from Gadamer's work. These three quotations are about reaching the other, the fusion of horizons, and dialogue. Next slide, please. In reaction to such formulations, William Eskridge, a Yale professor who has written many influential texts on statutory interpretation, aptly refers to a Gadamerian happy ending. Of course, Eskridge is mocking Gadamer, a rejoinder that takes me back to the gist of my own argument. If Gadamer's law does not work for the common law tradition, if Truth and Method effectively features Gadamer's Recht, then the idea that law as Gadamer has configured it, could play an exemplary role in support of philosophical hermeneutics becomes, I think, seriously compromised, and I would say unsustainable. It is not, of course, that transitional justice cannot benefit from philosophical hermeneutics insights. I think it can. To be sure, Gadamer can assist interpretation, and in particular can help legal interpretation and can therefore inform transitional justice. So there are things that we can learn from Gadamer's philosophical hermeneutics. But law as Gadamer has it, does not fulfill any exemplary role. Much more modestly, it is one discourse amongst others to which philosophical hermeneutics can be beneficially applied, as it does to other discourses. Thank you very much for your patience. Thank you for your attention. Muchas gracias a todos.
Tenemos algo como 20 minutos para preguntas, observaciones. Ya saben, ustedes pueden formularlas en español. Tenemos para ello aquí a Samuel, nuestro traductor. O si quieren hacerlo en inglés, pero por favor las traducen ustedes directamente también para que los demás comprendan. Sí.
Voy a hablar en español porque creo que esto es como un poco complicado abordarlo en inglés. De lo que entendí, uno de los problemas que presenta pues, este texto de Gadamer es que no tiene en cuenta los sistemas jurídicos del common law y que pues, toda esta teoría pues, está basada exclusivamente en un sistema greco-romano, como el que opera en la Europa continental y pues también acá en Colombia. Sin embargo, me llama la atención que si bien existe ese capítulo súper específico en Verdad y Método, no es la única parte del texto en el cual se hace referencia a la ley. Sí, ¿cómo quieres que...? Entonces, o sea, bueno, doy contexto, soy abogado también y digamos la cercanía que yo tuve con este texto fue sobre todo en el capítulo 9 en el que Gadamer hace como la reconstrucción del círculo hermenéutico de Heidegger. En ese capítulo en específico vuelve a tocar el tema de la ley y la forma en la que lo trae a colisión es con el concepto de prejuicio que trata Gadamer, que básicamente consiste en este mundo jurídico, tal como lo presenta él en ese capítulo, es que los jueces, a su vez, se tienen que basar en las decisiones judiciales. Después de... Ok. Gadamer se refiere específicamente al concepto de prejuicio, entendido en una lógica jurídica en la que los jueces tienen que tomar sus decisiones. Acá ya no habla de la ley como un texto escrito, sino que habla de las decisiones previas que tomaron otros jueces respecto de una situación igual. Y siento que esta descripción que hace en este pedacito pequeño de ese capítulo sí corresponde a una lógica muy parecida a lo que ocurre en el common law, a diferencia de lo que puede ocurrir en Alemania, en Francia, en Colombia o lo que sea. Y como para ir cerrando, como que a fin de cuentas lo que hace vigente en esa frase es que así como en el sistema románico ya hay algo dado que viene siendo el texto o la ley escrita, Gadamer dice, pues no lo dice de forma específica, pero uno lo podría llegar a entender de esa forma, que en un sistema de common law pasa exactamente lo mismo, solo que lo dado son aquellas decisiones que toman los jueces previamente que terminan sustentando esta nueva decisión.
Okay, may I just answer, respond? Okay. Thank you so much for this interesting comment. As far as I have understood, there are other passages that your colleague refers to in Truth and Method, which seems to be reflecting a little bit better or more the process of application in the common law tradition. Ah, yeah. Okay. In response to that observation, I would like to say a couple of things. First of all, I don't think that in 1960, Gadamer had any access to foreign legal materials, to foreign law, because the first textbook, the leading textbook in comparative law, introducing lawyers to foreign law, was published many years after 1960. So in fact, we have to place ourselves back in time. In the 1950s, 1960s, lawyers didn't have really much access to foreign legal resources like we do have nowadays. So if there are any passages in Truth and Method that may look more, that speak more to the common law tradition, that would be a pure coincidence and not be any in-depth reflection on the law. In addition to that, and that's my second point, is that I'm not saying that there is no process of application in the common law tradition, but we cannot talk about sameness. It will always be different. And that's something that lacks in Gadamer's work, this sensibility in law to these fundamental differences. Even the process of application will be different in Germany and France, in neighboring democratic societies. Or, for instance, I often, in my class on comparative law, I like to use the example of hate speech in the United States and in Canada, two neighboring democratic societies, and the concept of hate speech is interpreted so differently in the two countries that we can hardly speak of the same application. So that's what I wanted to say. Any reference to common law would not be explicitly and would not be would not be based on an in-depth reflection of Gadamer, because that would have been impossible at the time. He didn't have access to legal sources and materials like we do have nowadays. And secondly, still then, the process of application varies considerably from one country to another. It will vary from Germany to Colombia as well, right? And Colombia to Brazil, and so on and so forth. Even countries pertaining to the same legal tradition will ultimately reason differently. And that's something that I think lacks in Gadamer's work, quite understandably, right? When we go back to the 1950s or 1960s. So I'm not accusing Gadamer of having hidden some information. It's just he wasn't aware of that, okay? But it's nowadays when we can actually read Gadamer from a different perspective that we come to the conclusion where it's quite limited. Yeah. I hope that answers your question, but very, very interesting comment. Thank you.
Andrés, Fernando, Juan Ricardo.
Bueno, voy a decir en español y luego voy a intentar traducir a inglés. A ver si me fluye. Ah, bueno, está bien. Listo. Si no, en alemán. Sí, quiero preguntarle a la profesora acerca del concepto de sentido y la relación con el diálogo, ¿sí? Porque me parece que en la conferencia ella asume que el concepto de sentido consiste en como una captación literal de lo que está ahí, no como resultado de un proceso de diálogo. Igual yo voy a traducir entonces. Bueno. Sí, bueno, para todos. No, quería preguntar acerca de la relación entre el sentido y el diálogo, ¿sí? Porque me parece que la profesora asume que el sentido es la captación literal de un texto, y yo creo que en Gadamer el sentido siempre es resultado del diálogo, y en esa medida incluso uno podría pensar que esa actividad de interpretación está más asociada al common law que al derecho continental. So my question is about the relationship between the concept of sense or meaning, Sinn in German, and dialogue. It seems to me, but you can correct me, that you are assuming that Gadamer's concept of sense consists in grasping the literary meaning of a text. And I think that Gadamer's concept of sense consists in dialogue, is a result of dialogue. And I think that this is near to the common law tradition, and this conception of sense can account the power of judges in producing or making the law, not just interpreting the law literally, but making and interpreting it in different ways. And that's my question. I think you're assuming a literally account of sense in Gadamer's philosophy.
Thank you. Thank you very much. So first of all, in response to your question regarding the sense or der Sinn, the meaning, I think there are passages in his section on legal hermeneutics which are quite strange given his philosophical framework, because in that section he talks about the law's meaning, the meaning of the statute, der Sinn des Gesetzes, as if the meaning was somehow in the text, whereas in other parts of Truth and Method, he doesn't approach the matter in that way. So it's quite strange. And I think it's actually, when it comes to legal interpretation, he also talks about the legislator, and so the purpose of legal interpretation would be to try to find out what the legislator had in mind when enacting the statute. But as we all know, there is no single person as the legislator, but it's often a statute is a compromise, political compromise, and a statute doesn't really have one meaning, and that meaning changes over time, as we know as lawyers, because the legislator cannot foresee each and every situation. The text has to be applied to new situations or not. So indeed, I think your observation is very important and relevant. We need to rethink the meaning of Sinn in the context of legal hermeneutics, where it may have a different significance. Absolutely, that's a very good comment. Yeah, very relevant. Yes.
Gracias. Yo voy a formular la pregunta en alemán y después me traduzco. Ich frage mich nach diesem Begriff. Also bei Gadamer kann man das Recht als Bewegung der Tradition denken, aber, und das ist wichtig, also Recht und Gerechtigkeit, aber dieses Begriff ist nicht bei Gadamer, aber ja, das ist das Recht einer Tradition, das Recht einer Gesellschaft und so weiter und so fort, wenn Sie schon gezeigt haben. Aber ich frage mich immer, wo ist das Individuum, wo ist die Einzelheit bei Gadamer? Und das ist auch wichtig für das Recht, also für die Bewegung des Rechts. Also beispielsweise Unrecht. Unrecht, wer zeigt, dass etwas unrechtig ist? Also ein Individuum, nicht ein Subjekt, das ist Metaphysik bei Gadamer, aber ein Individuum, eine Einzelheit, eine Besonderheit. Ich frage mich, ob dieser Begriff der Anwendung konnte dieses Problem lösen. Also das heißt, also Anwendung bedeutet nicht nur die Anwendung des Rechts, sondern Unrecht. Also was würden Sie sagen? La pregunta es, digamos, en Gadamer es importante pensar el derecho dentro de la tradición, dentro de un ethos, dentro del movimiento de una historia, digamos, de la historia que somos. Pero hay algo que siempre se extraña en la obra de él, por lo menos en Verdad y Método, y que en el derecho es importantísimo también, y es la experiencia del individuo que dice, pero aquí hay una injusticia, aquí hay un no derecho, ¿no? Por lo menos, no sé si una injusticia en Gadamer, ese vocabulario es lejano, pero sí un no derecho. Y entonces lo que pienso es si la idea de Anwendung, de aplicación de la comprensión y de la interpretación, puede reclamar, allí puede aparecer esta noción de individuo, que es importante para pensar, digamos, la justicia y la justicia transicional también.
Sehr interessante Überlegung, very interesting reflection here. I would say, first of all, the way in which Gadamer describes the task of the judge, because he focuses solely on the judge's role, and is that he highlights the judge's subservient role. The judge is subordinated to the legislator, and basically that's it. And I think given the haste with which he has probably written that section on legal hermeneutics, he didn't have the time to explore this any longer and talk about Recht und Unrecht, Gerechtigkeit, etc. That is absolutely not addressed in his section on legal hermeneutics. And I think it is for us today to reflect on that and to see whether that can be covered by Gadamer's views on legal hermeneutics, or is this just too narrow, too limited in terms of reflection, right? So it gives rise actually to a lot of thought. There is food for thought, but Gadamer himself did not explore this any longer. So it is up to us to reflect on that nowadays, yeah. Especially in the context of transitional justice. Absolutely, yeah.